Good morning, friends. In this video, I am going to discuss very important point recently given by the Delhi High Court in the bail application, that is bail application number 3635 of 2022, and the decision of the case is 19th April 2023. The question which is addressed by this judgment is: does the victim's right to be heard include the obligation to be impleaded as a party respondent in the criminal proceeding? In the present petition, which was filed under Section 439, read with Section 482 of the Code of Criminal Procedure 1973, seeking grant of regular bail in case FIR number 320 of 2022, registered under Section 376 of the Indian Penal Code 1860 and under Section 4 of the Protection of Children from Sexual Offences Act 2012 at Police Station, Jaipur. On the first date of hearing, that is on 5th December 2022, while issuing notice on the petition, it was observed by the Honorable Court that the victim in the subject FIR had been made party respondent in the matter, though her name and particular have been kept secret. When inquired from the petitioner, his learned counsel for the petitioner said that this has been done on the specific direction of the registry of this court, and a report in that regard was called from the registrar, filing wide report dated 5th January 2023. The registrar cited section 439 subsection 1A of the CRPC and practice directions dated 24th September 2019 issued by the Delhi High Court to say that the petitioner was directed to implead the victim as a party respondent in the present matter in purported compliance and towards implementation of the said statutory provision and the practice directions issued by this court. In addition, the report also said that previously verbal directions were given by the Honorable Court that the victim complainant be arrayed in the memo of parties as a respondent after hiding the identity of the victim. Reference was also made to an order made by the coordinate bench where the appellant therein was granted permission to implead the complainant as party respondent. The report also said that the same practice was being followed in all matters being filed in this court relating to victims of sexual offences. So, going through this reply from the registrar, the court went further to see what is happening. So, it went into the development of law stages. First, they considered the judgment of Malk Arjun, who I did represented through legal representative versus state of Karnataka and others. In this case, Honorable Supreme Court highlighted the hurdles that victims face in assessing the criminal justice system after suffering violence visited upon them. The Honorable Supreme Court went on to observe that victims can no longer be sidelined and held that victims have a right to file an appeal against acquittal of an accused without having to seek leave from the court. And in another case, that is Jagjit Singh and others versus Ashish Mitra, alias Monu and others. In this case, the Honorable Supreme Court has accorded specific recognition to the rights of the victim, observing that victims cannot be expected to be sitting on the fence and watching the proceeding from afar. That victims have a legally vested right to be heard at every step post the occurrence of an offense. They have unbridled participatory rights from the stage of investigation till the culmination of the proceedings in an appeal or revision, and that the mere presence of the state does not tantamount to according a hearing to the victim of the crime. It is therefore clear that victims of crime can no longer be asked to remain mere spectators and must be accorded, in the words of the Honorable Supreme Court, unbridled participatory rights in the legal proceedings initiated in relation to the crime alleged to have been committed against them. No person can print or publish the name of the victim or disclose any facts which can lead to the victim being identified and which should make her identity known to the public at large. And in another case, that is Nipun Saxena versus Union of India, the Honorable Supreme Court has emphasized the requirement of maintaining confidentiality of the victim of sexual offences in the widest possible terms and in the following words. Neither IPC nor CRPC define the phrase identity of any person. Section 228A IPC clearly prohibits the printing or publishing the name or any matter which may make known the identity of the person. It is obvious that not only the publication of the name of the victim is prohibited, but also the disclosure of any other matter which may make known the identity of such victim. We are clearly of the view that the phrase matter which may make known the identity of the person does not solely mean that only the name of victim should not be disclosed, but it also means that the identity of the victim should not be discernible from any matter published in the media. The intention of the lawmakers was that the victim of such offences should not be identifiable so that they do not face any hostile discrimination or harassment in the future. And in another case, dealing with section 327 of CRPC, that is in Gurmeet Singh case, that was State of Punjab versus Gurmeet Singh. This court held as follows. The court should, as far as possible, avoid disclosing the name of the prosecutrix in their orders to say further embarrassment to the victim of sex crime. The anonymity of the victim of the crime must be maintained as far as possible throughout. In the present case, the trial court has repeatedly used the name of the victim in its order under appeal, when it could have just referred to her as prosecutrix. We need not know more on this subject. We need say no more on this subject and hope that the trial courts would take recourse to the provisions of the section 327 subclause 2 and 3 of the CRPC liberally. Trial of rape cases in camera should be the rule and open trial in such cases an exception. So in view of the aforesaid discussion, the court issued the following directions. Number 1. No person can print or publish in print, electronic, social media the name of the victim or even in a remote manner disclose any facts which can lead to the victim being identified and which should make her identity known to the public at large. Secondly, in cases where the victim is dead or of unsound mind, the name of the victim or her identity should not be disclosed even under the authorization of the next of the kin, unless circumstances justify the disclosure of her identity exist, which shall be decided by the competent authority, which at present is the session judge. Third direction was FIR relating to offences under section 376, 376A, AB, B, C, D, DA, DB, and E, and the offences under POCSO shall not be put in the public domain. In case a victim files an appeal under section 372 CRPC, it is not necessary for the victim to disclose his or her identity, and the appeal shall be dealt with in the manner laid down by law. Fifth direction was the police official should keep all the documents in which the name of the victim is disclosed as far as possible in a sealed cover, and replace these documents by identical documents in which the name of the victim is removed in all records which may be scrutinized in the public domain. Sixth direction was all the authorities to which name of the victim is disclosed by the investigating agency or the court are also duty bound to keep the name and identity of the victim secret and not disclose it in any manner except in the report, which should only be sent in a sealed cover to the investigating agency or the court. Seventh direction was an application by the next of the kin to authorize disclosure of identity of a dead victim or of a victim of unsound mind under section 228 subclause 2A to C of the IPC should be made only to the session judge concerned until the government acts under section 228A1C and lays down criteria as per our directions for identifying such social welfare institutions or organizations. And eighth direction, in case of minor victims under POCSO, disclosure of their identity can only be permitted by the special court if such disclosure is in the interest of the child. Ninth was all the states, union territories are required to set up at least one stop center in every district within 1 year from today. So, coming to from above discussion and conclusions, on the one hand, there is unbridled right of the victim to participate in all criminal proceedings relating to the crime, and on the other hand, insofar as sexual offences are concerned, there is also a legal mandate that the victim's identity must be kept confidential. So it is accordingly necessary for this court to explore as to how these two legal mandates must be effectuated so that one does not negate the other. Section 439 1A CRPC requires the court to hear a victim at the stage of considering bail petitions and other similar matters, and nowhere does that provision require that victim be made a party to such proceeding. The role of victim, even on being afforded the right to be heard, however, must vary with the context and the stage of criminal proceedings. In relation to bail proceeding, for example, The victim may assist the court in clarifying relevant facts, such as any threats received by the victim or other witnesses, or the possibility of evidence tampering, or even flight risk. However, the victim would have no role in determining, say, the necessity of custodian interrogation, which would be the job of the investigating agency. To reiterate, the right to be represented and be heard is distinct from the right or the obligation to be a party to criminal proceedings. Now, discussing another case, that is X versus State of Maharashtra and another. In this case, the Honorable Supreme Court had issued directions to its registry to ensure that in sensitive matters, if the name of the prosecutrix is revealed in the petition, this same is returned to the learned counsel for redacting the name before the matter is cleared for being placed before the court for appropriate orders. In Birbal Kumar Nishad versus State of Chhattisgarh, the Honorable Supreme Court has made observations as to the necessity of anonymization of the names of the victims, noting that it is well established that in cases like the present one, the name of the victim is not to be mentioned in any proceeding. We are of the view that all the subordinate courts shall be careful in future while dealing with such cases. Criminal matters relating to or arising from or concerning sexual offences. There is no requirement in law to implead the victim, that is to say, to make the victim a party to any criminal proceedings, whether instituted by the state or by the accused. Section 4391A of CRPC mandates that a victim be heard in proceedings relating to bail without, however, requiring that the victim be impleaded as a party to bail petitions. Supreme Court in Jagdish Singh has already mentioned Section 4391A must now be expanded to include the victim's right to be heard even in petitions where an accused seeks anticipatory bail. A convict seeks suspension of sentence, parole, furlough, or other such interim release. This is the direction of Honorable Supreme Court and Jagdish Singh that the victim should be heard in all the reliefs. To obviate any ambiguity, though Section 4391A CRPC makes the presence of the informant obligatory at the time of hearing, what is clearly mandated thereby is the right of victim, whether through the informant or other authorized representative, to be effectively heard in the matter. If necessary, legal aid counsel may be appointed to assist in representing the victim, and the mere ornamental presence of the victim or their representative without affording them an effective right of hearing would not suffice. So, this court is issuing the following directions. Most important point to be listened. The first direction is registry must carefully scrutinize all filings relating to sexual offences to ensure that the anonymity and confidentiality of the prosecutrix, victim, survivor is strictly maintained. Second, the name, parentage, address, social media credentials, and photographs of the prosecutrix, victim, survivor must not be disclosed in the filings made in court, including in the memo of parties. The identifying particulars would not appear in the cause list by way of abundant caution. The registry must ensure that such particulars do not get reflected in the cause list of the court in any manner. The name, parentage, and address of family members of the prosecutrix, victim, survivor, through whom the prosecutrix, victim, survivor could be identified, must not be disclosed in the filings, including in the memo of parties, even if they are accused in the case, since this may indirectly lead to the identification of the prosecutrix, victim, survivor. It is also directed that the files, paper books, e-portfolio of matters relating to sexual offences filed in this court must not be provided to any person other than the party to the litigation, to the prosecutrix, victim, survivor, and their respective counsel after due verification of the identity credential of such persons. At the stage of scrutiny of the filings, in the event the registry finds that identity credential of the prosecutrix, victim, survivor are disclosed in the memo of parties or anywhere else in the filing, such filing must be returned to the counsel who have filed the same to undertake requisite redactions before the filings are accepted. All services to be affected upon the prosecutrix, victim, survivor shall only be through the investigating officer in accordance with practice directions dated 24th November 2019 and not through the process serving agency, though a copy of the petition or application must be served upon the prosecutrix, victim, survivor. In effecting service as aforesaid, the investigating officer must remain in plain clothes so as to avoid any unwarranted attention. Investigating officer must also inform the prosecutrix, victim, survivor that they have the right to free legal aid, representation, in accordance with the mandate of the Supreme Court in Delhi Domestic Working Women's Forum versus Union of India and others. If the parties wish to cite in court any identifying particulars of the prosecutrix, victim, survivor, including photographs or social media communication, such party may bring the same to the court in a sealed cover or file the same in sealed cover or in a passcode locked electronic folder and share the same code only with the concerned court master. The foregoing directions are not intended to be exhaustive, and at the stage of scrutiny, the registry is expected to apply its mind to any other peculiarities of the given case with the aim and intent of sacrificially applying the directions of the Supreme Court in Nipun Saxena case. Lastly, the directions issued above may be summarized by way of written instructions, note, notification by the Registrar General of this court and be circulated to the principal district and session judges, Delhi, in their respective jurisdiction and to the Commissioner of Police daily. The Registrar General is directed to bring the judgment to the notice of Honorable Chief Justice for framing of appropriate practice directions and notice or notification as may be deemed appropriate in line with the mandate with the direction of Nipun Saxena. So, a lot of directions were given just to avoid harassment of the victim of sexual abuse. I have taken a lot of time, about 25 minutes. Thanks for accompanying me. God bless you all. Hoping you will like this video and subscribe.